Got it.
He's got great trust. This guy.
Yeah. Well, good morning, committee. So everybody's in a jolly mood here on St. Patrick's Day. So I remember I had a neighbor who was Irish, and he told me once that he said, "Come over, we're going to have an Irish special for lunch today." I said, "Well, what might that be?" And he said, "Well, that's a baked potato and a six-pack of beer." So, it was pretty good. Anyway, Senator Straub had called. She's on the way. She's just a few minutes late, but we're going to go ahead and get started. And we will begin with House Bill 2102. We want to proceed to final action on that bill, and so we'll have the reviser give us a description again, and then we'll proceed with amendments. Tamara, you want to overview 2102?
Thank you, Mr. Chairman, and good morning, committee. House Bill 2102 would clarify egg repackaging requirements for retailers, specifically for eggs repackaged at a grade higher than grade B. Subsection B of the bill provides the standards for repackaging grade B eggs, and the language in subsection B has been updated for clarity, but there are no substantive changes to those standards in subsection B. Repackaged eggs may be graded higher than B if the standards in subsection C are met. For these eggs, the bill would address some labeling and record keeping requirements, but maintain the health protection requirements for eggs graded higher than grade B, and I'll be happy to answer any questions.
Okay, thank you very much, Tamara, again. Any questions for the reviser? Seeing none, thank you very much. Next, we'll ask for, is there an amendment for today's meeting? Senator Francisco.
Senator Christian, I do have an amendment, and I'll pass it out. I've gone ahead. Tamara was very helpful in working with me on the amendment. It looks a little complicated, so I'm also handing out a sheet of paper that just we could walk through and explain some of what the amendment does. Senator Christian, when I looked at the bill, the way it's written, there is some repetition in terms of what happens or what requirements are made for each of these eggs. So if people look at just the sheet of paper that I provided in the back, is because we never print on new paper in our office. The first thing I'm saying is, although these eggs can include dirty eggs or eggs from containers with broken eggs, that's really not a requirement. So this now is changed. So that's part of the first part of the bill. So the next things are repackaged eggs that do the requirements for all the eggs, 1 through 5. They do not pose a health risk, they're not subject to an embargo, have not previously been repackaged, remain subject to inspection, and satisfy the standards of either repackaging to meet grade B or repackaging to be higher than grade B. So there's certain standards for repackaged eggs that meet B. It says in our bill that shall not be graded higher than grade B, but now that we have the rules for the higher, we don't really need that wording. And then the bill talks about repackaged eggs. This is in C on this page. Repackaged eggs may be graded higher than grade B if the following standards are met. And it talked about undamaged eggs from damaged containers. So by eliminating the wording from damaged containers, we are just focusing on damaged eggs. Doesn't matter what's happened to the container, because it's possible that the egg could be cracked without the container having been damaged. And then the final 4 are statements that we're only applying to repackaged eggs graded higher than grade B. So these are: no container is labeled with the declaration of enhanced quality, all eggs are handled and repackaged employing good manufacturing practices under refrigerated conditions, the damaged containers and packaging material identified with the United States Department of Ag are destroyed, and all damaged eggs, well, this says all, it says in the bill right now, all inedible eggs are segregated. So my concern is those, I believe those 4 statements should apply to the packaging of eggs that are going to be grade B, as well as eggs that are higher than grade B. So what the amendment does is it puts, combines those 2 sets of requirements and puts them or under the list of requirements. And then elsewhere in the egg law, there's a statement that about fees, and it says the inspection fee shall be paid only once on the same quantity of eggs, so long as such eggs remain in the original container. And I'm adding, or have been repackaged in accordance with this act and are graded higher than grade B. So my understanding from some conversations with the department is those repackaged eggs that are grade B are being put into new containers and they will probably get a new stamp. But the thing that we're trying to do to help retailers waste less food is to allow them to repackage eggs in the a container that is already labeled from the same distributor and packer information. So those containers already have the fee stamp, and we don't need to charge another fee stamp for that repackaging. I'd be happy. I know it's a little confusing, but I'm really hoping that what this does is end up being a cleaner statement about repackaging eggs in our statutes.
Okay, thank you very much, Senator Francisco, for your work. Are any questions on the amendment? Senator Ware.
Thank you so much, Mr. Chairman. Not so much a question as a comment. This is really excellent work by Senator Francisco, and, it makes it clear, whence we come. Thanks.
Okay, thank you very much. With that, would you like to make your motion?
Thank you, Mr. Chair. I move my amendment.
Is there a second? Motion made in second to move the amendment. Any discussion? All in favor? Oh, Senator Fagg.
Thank you, Mr. Chairman. You know, and I appreciate the work you've done on this. I really do, Senator. When I read this, it reminded me of a picture I saw one time of a guy riding a horse, and there was a basket, you know, that he was going to, OSHA had been there. He had a basket to fall in, he had his stuff on, he had a helmet on, you know, he's so much like this. The thing I was concerned about, as much as went into this, in the spirit of free enterprise, I wonder how the industry feels. You don't want to have to go pull a dictionary out every time you do something to make sure you're doing it right. And that was my thought that kind of went into that. If we had a lot of proponents on this, this was never an issue with any of this. I don't want to make it too cumbersome for the industry. That's where I'm coming from. And give them something. You know, when you look at their statement, do they pose a health risk? Well, what's a health risk? You know, and that kind of thing. I mean, there's all kind of things that could come into that, and the deeper you dig, the worse it gets. And in the spirit of free enterprise, I was happy with what the amendment was there, so I just wanted to, that's just my opinion, but I understand totally where she's coming from too, so.
Okay, Senator McGinn, who's next?
As a egg producer, I'm not personally, but the chickens that I have, I appreciate the clarification just because I belong to a food and farm council in Harvey County, and we often talk about the egg packaging law, and that it's just not, some things needed to be clarified. So I think this is a nice first attempt to clarify some of that language in this, and you know, maybe we'll be back here next year making an adjustment, but I think this is probably a good effort. So thank you.
Okay. Senator Straub.
Thank you, Mr. Chairman. Having carried this bill last year, I'm just curious as to where the language in the fifth bubble, where eggs do not pose a health risk, they're not subject to an embargo, where did that language come from, or is that new language that you created?
That language all came from the bill that was presented to us from the House this year. So if you look, a health risk comes from page 1, line 15. So it says the eggs, you know, which may include dirty eggs or eggs from containers, do not impose a health risk. And then if you look again on page 2, lines 6 and 7, the eggs, which may include dirty eggs or eggs from containers with broken eggs, do not pose a health risk. So what I was doing is just saying it once instead of saying it twice, because so when you go through the list, you know what applies to everyone who's repackaging, and then we specifically say, what do you have to do if you want to meet grade B, and what do you have to do if you want to meet higher than grade B, and all you see are the special requirements for meeting those grades instead of all the other requirements for repacking eggs. So the only thing I really changed in that balloon was on number 8. In the bill that we had, it said all segregated inedible eggs are properly destroyed to prevent human consumption. So I think if the egg is inedible, humans aren't going to be eating it anyway. And these cracked eggs or damaged eggs are probably still edible. This would allow you to feed them to your pigs.
Thank you for clarifying that.
All right, any other discussion? Senator Francisco.
I was wanting to know if that helps Senator Fagg know that this is not additional wording and the department has had a chance to review it.
Are satisfied with it.
Thank you.
Any other discussion? We're going to vote. All in favor of the amendment, say aye. Aye. Opposed, no. Motion carried. The amendment is passed. Any other amendments or discussion? Seeing none, I would entertain a motion to pass the bill out favorably. Senator Francisco.
I move we pass HB 2102 out favorably as amended, And I would recommend that we ask for a substitute bill. Just because there's so many changes have been made, I think it would be easier to read on the floor. We could ask our reviser.
Okay, that's your request? We can do that. Is there a second to the, that's not favorable? Second by Senator Ware. Any other discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. The bill is passed favorably. And I'll get with the reviser on the, okay. That takes care of our first item of business. Next, we're going to move into our hearing on hemp, House Bill 2244, and we'll start with reviser Tamara. Go ahead.
Thank you, Mr. Chairman. House Bill 2244 addresses two matters relating to industrial hemp. The first part of the bill would establish certain requirements for the effective disposal of industrial hemp, and the second part of the bill would transfer the Kansas Department of Agriculture's statutory authority to register hemp processors to the state fire marshal. So I'm going to talk about the effective disposal here first. Section 1 would establish the requirements for the effective disposal of industrial hemp. The Kansas Department of Agriculture would be required to develop a plan for effective disposal in coordination with state and local law enforcement. Whenever anyone licensed under the Commercial Industrial Hemp Act is required to dispose of industrial hemp, the department would be required to notify state or local law enforcement in the jurisdiction where that hemp was grown. Additionally, the department would be authorized to perform any action necessary to ensure the effective disposal of industrial hemp. That would include taking temporary possession, destroying, or supervising and directing an appropriate method of effective disposal. State or local law enforcement would be required to approve in advance any such action. The bill would allow the Secretary of Agriculture to require any employee or agent of the department who participates in the effective disposal of industrial hemp to be fingerprinted and submit to a criminal history record check. The bill would also allow the department or state or local law enforcement to seek reimbursement from individuals licensed under the Act for costs incurred in conducting effective disposal of hemp. And finally, for Section 1, it would explicitly state that the department has no authority to conduct effective disposal of industrial hemp or cannabis plants produced by individuals who are not licensed under the Commercial Industrial Hemp Act. So I'm going to switch gears and talk about the second part of the bill relating to hemp processors and the state fire marshal. So I'm going to go to Section 4 first. And Section 4 would transfer industrial hemp processor registration and oversight authority from the Department of Agriculture to the state fire marshal in statute. So currently, under last year's budget bill, Senate Bill 66, the state fire marshal was tasked with registering and regulating hemp processors. And I believe a similar provision is also in this year's, at least the Senate version's budget bill for this year. And House Bill 2244 would put that current practice into statute. Under the bill, industrial hemp processor registrations would expire annually on June 30th instead of the current April 30th. And a registration fee maximum would be increased from $200 to $1,000. The bill would also revise and clarify the fingerprinting and criminal history record check requirements for hemp processors. The bill would require the state fire marshal to adopt rules and regulations, including for the collection and disposal of any cannabinoid extracted during the processing of industrial hemp that cannot be lawfully sold in the state. The bill would also allow the state fire marshal to grant an exemption from the application of a specific requirement of such rules and regulations. Subsection J would require the Department of Agriculture and the state fire marshal to coordinate with one another as necessary for the enforcement of laws or rules and regulations relating to industrial hemp. Section 2 of the bill would give the state fire marshal the authority to issue stop sale, use, or removal orders when the state fire marshal reasonably believes that hemp products are being produced, sold, or distributed in violation of the Commercial Industrial Hemp Act. Those orders would be valid for up to 7 days. Additionally, there's some funding clarifications, and the bill would take effect upon publication in the Kansas Register, and I'll be happy to answer any questions.
Okay, thank you very much, Tamara. Committee, any questions for the reviser? Senator McGinn, was that did you wave it? Oh, okay. Sorry. I didn't want to miss anybody. Okay, we will start with our proponents. We'll begin with our first proponent, Kenny Titus from the Kansas Department of Agriculture. Welcome to the committee, Counselor.
Thank you, Mr. Chairman, members of the committee. My name is Kenny Titus, Chief Counsel for the Kansas Department of Agriculture. We're here today in support of House Bill 2244. As usual, the reviser gave a very good summary, and it's important to note there are two specific parts to this bill. The first is a bill that you guys would have seen last year or almost saw last year, I guess, before it got canceled, with the destruction of unlawful hemp in the field. To explain that process and why we're bringing forward this, there's a long process with USDA and their rules and what they require for the destruction of hemp that is out of compliance, which would be hemp that grows to have a THC content of 0.3 or greater. And in their interim final regulation, they had initially required that anytime there's hemp in the field that is above 0.3 THC, it either had to be destroyed by law enforcement or a DEA reverse distributor, which is someone licensed by the DEA to deal with controlled substances. That potentially creates an extra burden on law enforcement that could be expensive and time-consuming based on how large some of these fields may be, and the average county sheriff doesn't want to go out and have to clean out an acre or two of hemp, even on a smaller scale. So that was our first concern. The reverse distributor option isn't really a viable option. Those folks are mostly licensed to deal with prescription drugs, not the top-tier controlled substances. So that left us without a really good solution. USDA did recognize this pretty soon after entering their interim final order, and they actually suspended enforcement of those provisions because they were unworkable. We've waited a full year since we were here last year. They've now issued a final rule that will take effect later this month. They have loosened some of those restrictions, but they did retain language that says if you don't do this in a very specific way, we still expect law enforcement or reverse distributor to be the ones to destroy this hemp. So what this bill does, it lays out a process where we as the department, if we have hemp that needs to be destroyed in the field and it can't be remediated or plowed under or for whatever reason or the producer simply refuses, we'll cooperate with the local county sheriff. It lays out the steps. We'll develop a plan. It eliminates any problem with KDA personnel as not being law enforcement because we're acting with and under the supervision of law enforcement to go out in the field and make sure that the material is properly dealt with if needed by federal rules. So it doesn't require that this process be followed in normal circumstances, but if federal law says we need to go above and beyond the normal remediation procedures, we have this plan in place. The second piece of this is transferring the regulation of industrial hemp processors to the state fire marshal. This was actually done temporarily by a budget proviso last year. The fire marshal can talk about his rule and reg process, but he has rule and regs up and is now handling processors moving forward. And so the changes in the processing bill are a reflection of things he's learned over the year in adopting his regulations. I would note we have changed how background checks are done. That entire statute was really the process of a sort of a compromise when we went to conference committee on the Industrial Hemp Act in the first place. There were a lot of issues with what KDA should or shouldn't be responsible for. And we worked with the fire marshal, the attorney general's office, the KBI, to find a solution that sort of met everyone's needs to make sure processors were properly regulated. And the changes we're bringing forward to the processing statute are a result of those discussions. So I'd be happy to answer any specific questions you might have about these.
All right, thank you very much. Any questions? Senator Ware.
Good morning, Kenny. Thank you, Mr. Chairman. Good morning. So are you telling me that it's days away from the USDA finalizing their new levels and ways of operating?
So the final rule, it was released January 15th. It'll go final on March 22nd. It was under review by the new administration, so it was actually released by the previous administration. They were reviewing the rule to make sure they wanted it to take effect. We found out late last week that USDA announced they were going to allow the rule to take effect. And so there are some, it allows for greater remediation. So if you wanted to strip off the flowers and use a fiber product, it allows for on-farm destruction of hemp in most cases, and it allows, it changes some of the negligent levels to allow your crop is still out of compliance if it's above 0.3 THC, but it's not considered a negligent violation until it goes above 1%. It opens up a wider testing period, longer time, and so that's not, those changes aren't actually related to this bill, but we are having our advisory committees reviewing new regulations to implement those changes on Friday, actually, and our plan is to have all of those changes in place by the fall harvest, so.
And so the federal government is loosening in many ways, the industry.
In general, there were a number of changes, a couple of things we thought they might loosen, they didn't, but generally the new final rule fits Kansas's needs better.
Okay, perfect. And we're 10 days away from that.
Give or
Okay.
take, yeah.
Thank you. Just wanted to clarify. Thanks.
Any other questions for Senator Francisco?
Thank you, Mr. Chair. So you told us that there's still an opportunity for people to just take care of this themselves on the farm.
And that'll be the primary method. We've in the cases, we've only had one issue where someone had an out-of-compliant crop and we actually had to issue an order to them. Normally, they get their test that says they're out of compliance. We return the test and say, the regulations say you have 7 days to destroy this crop or let us know you need more time. And we've had 0 compliance issues. Even the one we had to issue an order, it was ultimately ended up not being a big deal, so.
Senator Francisco.
Thank you. So when I'm reading this, it just says whenever a person licensed under the Hemp Act is required to conduct effective disposal, the Kansas Department of Agriculture shall notify state or local law enforcement agencies. So where is the piece that they can handle it themselves and you're not already working with state or local law enforcement?
So in this case, we specifically wrote this paragraph A. It says when you have to conduct effective disposal of hemp pursuant to standards established by the Controlled Substances Act or DEA regulations. So that's a higher standard than is used for the on-farm disposal methods. So when those higher methods are required, so basically it's a drug action is how the federal government is doing it. So when we have to follow those regulations to destroy something, then this is the process we would follow, and it requires us to involve law enforcement. If we ever have any concerns or something tests too high, we do have standards where we would notify the county sheriff of what's going on. So that does happen now occasionally.
All right. Any other questions? Thank you very much, Kenny. Our next proponent is Mr. Robert Jacobs from the Kansas Bureau of Investigation. Welcome to the committee, Robert.
Good morning, Chairman Kirshen and members of the committee. I appreciate the opportunity to be here today. My name is Robert Jacobs. I serve as the Executive Officer for the Kansas Bureau of Investigation. We are here today to show our support of House Bill 2244. We appreciate the work that the state fire marshals and the Department of Agriculture did together for the research and the creation of this bill. We're concerned about any hemp product that would have over a 0.3 THC level and the potential dangers that could be to public safety. And so we appreciate the work that they did in coming up with a disposal mechanism for that. When the Hemp Act was passed in 2019, I think the Department of Agriculture realized that they were going to need a system for disposing of hemp that was outside the legally allowable limit. And so they came up with this disposal process. We also appreciate the ability of their willingness to work with local law enforcement and help to have that disposal process go forward so that it reduces the strain on local law enforcement and some of their resources. One of the big issues that I think I want to discuss this morning regarding this bill is the national criminal history background checks. Currently, the producers are already, those checks are already being done for producers. However, House Bill 2244 will address the fact that we cannot do them for the processors. By federal law, we're not allowed to conduct national searches unless there's very specific language in statute that allows us to do that. So under the proviso, we thought we might be able to do that. To give you some background there, once the proviso happened under Bill 66 last year, we reached out to the FBI. We asked if we could do those checks through with the proviso in place. They said no, that they would not accept that. It had to be codified in statute, so we were not able to do that. So we've had to come up with an alternative method until we can get this fixed. House Bill 2244 will fix that. It will amend that language and place that language into statute that would allow for the national fingerprint record checks for the processors as well as the producers. Finally, we just appreciate that the fire marshals work on this and their ability to promulgate rules and regulations that will provide oversight and regulation over the hemp processors. There is some concern for the transportation of hemp over the highways that may have a level of above 0.3%. And so by putting some of the safeguards in place through the rules and regulations, we hope that that will provide the necessary security for allowing that hemp to move and then to go on to be processed. So beyond that, I just wanted to add that we encourage the passage of House Bill 2244, and we appreciate the opportunity to come today and present testimony. I'd be happy to stand for questions.
Okay, thank you, Mr. Jacobs. Appreciate that. Anybody questions for Mr. Jacobs? Seeing none, thank you very much. We'll move to next proponent is Doug Jorgensen, State Fire Marshal. Welcome to committee. Wait a minute, I get it. Yeah, there we go. I skipped over somebody. Ed Klump was, okay, there we go. Okay, well, sorry about that. I looked down the street too much. Go ahead, we'll have you.
Thank you, Mr. Chair and Committee.
I apologize for that.
My name's Doug Jorgensen, currently the State Fire Marshal for Kansas. I'm appearing before you this morning in support of House Bill 2244 and the amendments that it puts through for KSA 2-3907. Our office was asked to sort of fill a void in the oversight of the actual processing, extraction process of industrial hemp, and we're more than glad to assist the other state agencies that are already involved in this program. We feel that our Fire and Life Safety Division is a good fit for making sure that the extraction operations are safe from fire and explosion, and that our Investigation Division, who currently inspects and regulates state fireworks and the explosive industry in the state, have a good handle on being able to look at bills of lading, receipts, and other records, which I think will be needed in this process going forward. We want to make sure that in this processing of the industrial hemp, that any THC waste products or products themselves are disposed of properly. Because currently under the Controlled Substance Act, nothing can contain THC or be transported or sold if it's above 0.3%. So there are some issues with our rules and regs from the processors because they'd like to see that to be higher, but currently under the state drug laws, nothing can be sold, transported, or processed outside of a processor facility if it's above the 0.3%. The controlled destruction of the byproducts, I think, is essential because out of some of these processes, one of the waste products or byproducts can be pure THC, which has a street value. And we just want to make sure that those things are done properly and that everything's accounted for. On the rules and regs, our temporary rules and regs are in place. We're working on pushing those to permanent status. We've currently identified about 8 to 10 processors in the state that are still in operation or that might want to be in operation. And we've received applications from about 8 of those so far. And with that, I'll stand for any questions.
Okay, thank you very much. Any questions? Oh, Senator Ware.
Thank you, Mr. Chair. Good morning. So I'm curious that the idea that the byproduct would be pure THC is new to me. Can you explain that idea and such?
Well, in the processing process, if a processor is taking the industrial hemp through the whole process to say like a CBD oil, all of the THC needs to be extracted. And when that THC is extracted, that is a waste or byproduct. And when you extract that THC, you basically have a pure form of THC that's available for sale on the street.
But I'm not a processor, and I really don't understand all of the chemistry and the mechanics of how that might work. But in my conversation with a couple of the processors that are currently in operation here, they suggested that was not quite, that there would be some concentration possibly, but that it wasn't, it made sense to me, okay, of course you're pulling out the THC, so here's the THC. But they said, no, it's far more complicated than that. Okay, I'll ask them about it in a minute.
Same conversation with the processors, but for right now, we are going to set tours of 2 or 3 of the processing facilities in the next week or so we get a better understanding of how they actually operate, because they all operate a little bit different. But we're basing our THC information from the KBI laboratory. And the chemists in the KBI laboratory say that in this processing process that there is THC, pure THC that's developed as a byproduct or a waste product.
Senator Alley.
Thank you, Mr. Chair. You mentioned twice in your letter here about explosion. What is the risk of explosion?
Exposure?
Explosion.
Explosion? It depends on the process. Most of the processors in the state use ethanol for their extraction process, so there is a danger of explosion or fire because of the ethanol that's being used. There's one processor that uses CO2, but the majority of the processors in the state use ethanol.
Okay, any other questions? Senator Francisco.
Thank you, Mr. Chair. I see that your office would be the one responsible for rules and regulations. Is there a reasonable deadline for those that would be comfortable for a year or?
Currently, we have temporary rules and regs in place since February 1st. And the reason we instituted those February 1st is that the authority of Department of Ag expired the end of January. So we had to have temporary rules and regs in place February 1st, or the current processors would have had to close their doors. So we have temporary rules and regs in place as of February 1st. We're working on the permanent version. We've had one meeting with the processors in the state so far, and we're continuing those discussions with them. We've filed everything with the Secretary of State's office, and they have set a public hearing on our permanent rules and regs for May 11th. So by June, probably July, those permanent regs should be in place.
Thank you.
Okay, thank you very much, Mr. Jorgensen. And one more question. Senator Fagg.
Thank you, Mr. Chairman. A couple of them. One, when I looked at you're going to collect $1,000 and then annually. Actual cost to your department's going to be a lot higher than that. So I'm kind of concerned. And then the state fire marshal, I don't know what offices you have around the state. Maybe you have a lot of them. I was thinking by the time you run around and look at 12 of them all over the state and all the stuff that goes in, the cost part of it, I'm wondering if the revenue is enough to cover what's going there. So that's one question. Go ahead.
We feel it is. There's currently, again, we've only received 8 applications. And I think at the end of January, Ag only had about a dozen processors on their list. And a couple of those have gotten a license over the last couple of years, but actually never started a business. They only got the license in case they decided to start. So we're in the range of about 10 processors, probably. Our investigators now live out around the state, and they're assigned different regions. In the same way with our fire and life safety inspectors. They all live out around the state and have assigned different regions. So we don't feel it's going to be a big draw on our staff or our time to include these 10 or 12 processors in our day-to-day operations. And we feel that $1,000 is sufficient. Right now, that'll help pay for some of the expenses for our staff, but we currently are having to pay for the background checks. And since they're not a law enforcement entity to do both the state and federal checks, I think it's going to run around $45 to $50 a person each year. So depending on the amount of staff they might have or whatever, we'll use up some of that $1,000 just in doing the backgrounds.
Thank you. The other question I had was that I read through here like the KDA and the fire marshal to coordinate with one another in providing requested information from the other. I would think it'd be important to have the local authorities involved with whatever kind of reports you have, just so the coordination's going on, because they might think something's going on and some guys got a little stuff going on somewhere else. I would think the coordination with local authorities would be important in that too, just my opinion.
And I think somewhere in the statute, there is language, and I'd have to refer to Kenny, but I think there is language that allows us to stay in contact with local authorities even as we do our process. And I think we're even to notify local authorities if there's a processor in their jurisdiction.
Okay. All right. I didn't see that, so I could have missed that too.
Other questions? Senator Straub.
Thank you, Mr. Chairman. And I'm not sure if you're the correct person to ask this question to, but I don't fully understand the whole process of extraction of the THC or getting it as a byproduct in that process. But is there much difference really between hemp that would have, say, 0.3% THC and hemp that would have 0.4% THC? I assume that there's a byproduct of THC regardless of the level of it. Is that correct?
With the 0.3%, the byproduct of THC is quite a bit less, unless, if you would be processing hemp that had 10% or 15% THC. But there is that THC residual even from processing the 0.3% hemp. That has to be accounted for and controlled.
Correct. So in Kansas, because of that, that byproduct must be disposed of properly, I assume, or can it be sold?
The THC byproduct needs to be disposed of, but In discussions with the processors, we've become aware that some of the byproduct, which is the ground up hemp or the powder or things, there is a market for that some farmers might want to actually put back into their fields. So we're, again, in conversation with the processors, and as long as that particular byproduct didn't contain any THC, they'd be free to sell that to whoever they want for whatever use is out there.
So if a Kansas hemp producer sells their whole product out of state where, say, recreational marijuana or whatever is legal and doesn't have those same restrictions, can a processor in another state extract that THC and actually sell it on the market legally?
Probably, depending on the laws of that state, they could probably do that.
So does our overregulation of the processing of it hurt the hemp industry in Kansas?
Well, I wouldn't, categorize it as overregulation. We're only regulating based on the current Controlled Substance Act that the state has. And we don't have the ability to sort of hedge on that and allow processors to process and sell anything above the 0.3% right now because it's against the law under the drug statutes in Kansas. So that's where we're at in this process. Is I understand the processors' concerns because they say that when they process the industrial hemp at 0.3%, their intermediate substance or distillate, which is the oil, sometimes contains anywhere from 1% to 3% THC. And they've been selling that or distributing that to other processors or even out of state. But currently, under the state drug laws, that's illegal to do.
Okay, I'm still gathering and processing, and I'm in no way suggesting that we should have legalization of marijuana. I'm not suggesting that at all, but I also want to make sure that we're not hindering ourselves in competing in the industrial hemp market. I have a background in textiles, so I know that the fiber can be very useful. So I'm just trying to gather all of the pieces and not hurt our farming operation in the process.
I understand, yeah. And it's turned into being a little bit of a balancing act between the current processing and state laws. But you know, I think ourselves, the KBI, Department of Ag, we're doing our best to sort of mediate that the best we can under the current statutes.
Senator Fagg.
Thank you, Mr. Chairman. Just a quick question to you. We don't get State Fire Marshal in front of us very often. If you have illegal growing going on in your county, does the State Fire Marshal get called on that?
No.
Okay. Thank you.
Any other questions? Seeing none, thank you very much. Committee, we're getting close on time, but I think we can have one more proponent, and from the Sheriff's Association, Mr. Klum. Welcome to the committee. Sorry.
Thank you, Mr. Chairman. I am Ed Klump. I'm here representing the Kansas Sheriff's Association. I'll make this quick because I know you're short on time. Basically, we just want you to know that we are glad to be cooperative partners with the state agencies in trying to present a program that works for the hemp producers, the hemp growers, and also to avoid the unnecessary diversion of high THC byproducts into the public. It's been a very good experience with us, both with working with the state agencies from the very beginning of this to work out how we can work cooperatively to make things work well for everybody involved. And we continue to work with the Department of Agriculture to find these appropriate ways to deal with this disposal issue. We think this is a good program. We have had a good experience with our hemp producers in the state. The sheriffs tell me they have a few things that come up, but nothing very big, and by the most part, everybody's working together very well on this. The diversion aspect, when you get to the processors, is one of our biggest concerns. As we explored this when the agricultural hemp was first being developed, that was one of the things other states told us to really be cautious of, because that is the point where you have high THC items that are ripe for diversion. And we think the things that are in place in this bill are appropriate. We think they're adequate to help us control that, and at the same time offer the latitude that the producers and the hemp growers need to make a profit and make this work in the state of Kansas. So with that, I'll answer questions.
Okay, any questions from the committee? Seeing none, thank you very much. Committee, we have maybe Mr. Barone, we have a few minutes left if you'd like to make a few comments. And we're going to, committee will suspend the meeting, the hearing, and we'll conclude it tomorrow. So everybody got a chance to visit. So welcome to the committee.
I think that'd be good. Again, thank you. My name's Kevin Barone. I represent some of the processors, some of the farmers in this world. And I think tomorrow you'll hear from some of the processors. It was my understanding that for the last several years, the KBI did not have the ability to test the amount of THC in any product. They could only test whether that product had THC or not. So there was always an issue with this, whether or not whether something had more THC in it than it was supposed to. It was interesting today that the fire marshal said that the KBI labs is what tests them to let them know where that is. There's a lot of misunderstanding with the industrial hemp program in Kansas. And it is very much a strong program if we can get past these misunderstandings, because this is a crop. This is not a drug. And it's looked at like a drug more than anything else. And I think our processors will talk about that tomorrow. I'll keep this short because I know your time's limited. But when you talk to them, we have two of them, one out of Wichita and one out of Southeast Kansas. One does ethanol and one does CO2, so you'll get to hear from both of them, and you'll get to hear that the limitations that are being put on them are really making them look to go to other states where hemp is treated like a crop. And I'll let it be for that.
Okay.
Thank you very much, sir.
Thank you, Mr. Barone. We'll see you tomorrow then. Committee will suspend the hearing and take it up again tomorrow with our other business. And with that, we are adjourned.